Sure. I'm Randy Barnett. I'm the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center, where I also direct the Georgetown Center for the Constitution. Judicial activism was a pejorative term coined by Arthur Schlesinger Jr. in the 1940s to criticize some of the New Deal justices who started to protect rights that were not specifically enumerated in the Constitution. And he accused them of activism. It was a charge that had been invented to delegitimate the concept of judicial negation of legislation, judicial invalidation of legislation, because ostensibly the argument goes that an unelected, unaccountable judiciary is standing in the way and thwarting what Theodore Roosevelt called the popular will, or the will of the people, and they should not be allowed to do that. And Theodore Roosevelt made that argument when he was running for president as a progressive in 1912. That's where judicial activism came from. It's a way of getting the court not to do its duty. Pretty much everybody who's listening to this video believes that the court ought to follow the Constitution, ought to invalidate laws that violate the Constitution. If invalidating a law itself is activism, everybody who's listening to this video believes in activism. That shows you that activism is an empty phrase that doesn't really tell you what you want to know, and that is when should the court invalidate legislation and when should it not. And everybody agrees you should do it. So, I'm one of those who favor judicial engagement as opposed to either activism or restraint. Judicial engagement is judicial restraint. It's basically the judges should be restrained by the meaning of the Constitution. So even where they don't want to strike down a law because it's popular, they should strike down the law because the Constitution, it's contrary to what the Constitution says. The whole activism trope is one that, as you mentioned, Justice Ginsburg thinks the court is activist. Why? Why does she think that, even though, as Adam Liptak points out, it doesn't strike down very many laws? Because it's striking down some of the laws that she thinks should be upheld. And she doesn't have any problem voting for invalidating laws she thinks are unconstitutional, and she shouldn't have any problem with that. And so activism is solely in the eye of the beholder and is not a very helpful concept. I mean, part of the problem we have today, we have a lot of problems today with the way we think of the Constitution. One of the problems we have is that we think of the power of judicial review, and then we try to justify that. That's a modern concept, the power of judicial review. At the time of the founding, no one spoke of the power of judicial review. They spoke of a duty of judges to follow the law, the duty of judges to follow the Constitution, and if the Constitution says that a particular act of legislation is not proper, it's not allowed, then the duty of the judges is to follow the higher law. Now, why change the rhetoric from the concept of the judicial duty, to the idea of a power of judicial review? Because powers should be exercised with discretion. Powers should be exercised with restraint. We all have powers, but we should be discreet about how we exercise them, and we should be restrained. We don't think of duties that way. We don't think, well, you should be, you should exercise you should comply with your duties with discretion, or you should be restrained in adhering to your duties. No, if you have a duty to take care of your children, you don't do that with discretion. You fulfill your complete and total duty to your children. And so the move from duty to power was a way of delegitimating the power or the ability or the right of the third branch of government, the judicial branch of government, to have to agree that a measure is constitutional before that measure becomes law. So if Congress thinks a measure is unconstitutional, they never pass it. The Supreme Court never gets to pass upon it. If the president thinks a measure is unconstitutional, he can veto it. But for a measure to be found to be constitutional, all three branches, including the judiciary, must concur that it's constitutional. That is not a power to interfere with the other two branches. That is the way the system is designed, so that you have this redundant backup system, this redundant safety mechanism that you have to satisfy all three branches before the law gets imposed on the sovereign people. And if the courts are basically going to defer to the legislature, then they're not doing their job. Let me just bring up one additional problem with the way we currently think of things, the way constitutional law is currently done. And it's the problem that I call double deference, the problem of double deference. You have the court having a whole series of doctrines that say we defer to the legislature, otherwise we'd be activist. We defer to the legislature's judgment about whether something is within their constitutional power. All right, now you just go across the street and you ask the congressmen and the senators whether what they're doing is constitutional, and what answer will you get from them? The answer you get from them is, it's constitutional because the courts will uphold us. Well, wait a second. The courts are upholding them because they're deferring to Congress's judgment. You ask Congress about its judgment of constitutionality, says what we're doing is constitutional is because, look over there, the courts are upholding us. And if, according to this way of looking at things, no one ever looks at the Constitution independently. Each side is looking at the other side, and the Constitution drops out. This is a game that's played so that the Congress can do what it wants, and so the so-called popular will can prevail. The Constitution is there to constrain that in order to protect the rights of all the people, not just a majority and not just a well-connected minority, but all the people, including those people who don't have the political clout to prevail in the legislature, including those people who don't have the political clout to prevail in the court, because they haven't been recognized yet as a legitimate aggrieved group. They are that far out. So before you ever get protected by the court, you have to be sufficiently politically influential before the court's prepared to protect you. Well, I wouldn't say it's mistaken muscle. I would say in some respect it's correct muscle. You have a country that's very closely divided. We're either a 50-50 country or we're a 40-40 country with 20 in the middle. But we're a very closely divided country, and given the way our constitutional order is set up, that means we have divided government, and when we have divided government, it's difficult to, quote, get things done. That's the way it's supposed to be. Difficult to get things done if there's divided government. And when the Republicans took the House after the Affordable Care Act was rammed through the House and Senate, they have a responsibility to their constituents to represent the views that, according to the theory of representative government, they're supposed to represent the views of their constituents, which are contrary to the views of the majority who are currently in the Senate and the person who holds the office of president. I do think, in answer to your question, that when the country is that divided, it does give the Supreme Court more room to move, because there's no popular overwhelming sentiment for one thing as opposed to other. When there was a popular overwhelming sentiment to protect us from Japanese invasion, and that required, in the opinion of the executive branch, the internment of American citizens of Japanese ancestry, the court was not going to get in the way of that, because there was an overwhelming popular sense that this had to be done, and the court was just not going to stand in the way of that. When there was this popular sense that the North was going to have to, the federal government was going to have a hands-off policy towards Jim Crow and segregation in the South, the court was not going to get in the way of that. They just weren't. Here, when we have a much more closely divided government, you have each side of the court more prepared to essentially take the positions that they think are constitutionally required, because they're not bucking an overwhelming majority on the other side. And so when you have a more evenly divided country, you can have a more evenly divided court, and that's what we have. The mistaken muscle is actually not a good metaphor, because what the court's doing that's improper is standing aside and letting the other branches do what they want. It's rarely doing the wrong thing when it says no. It's almost, where it does the wrong thing is when it said yes. And so, I mean, I'm not saying it never does the wrong thing when it says no, but that's a very, very small percentages of the mistakes that it's made. Most of the mistakes that have been made have been errors of omission, not errors of commission. And so in that sense, they're not using their muscles. They may have good reason for that. There may be institutional reasons for that, but I think the safest course of action for all is just to follow the Constitution, where the Constitution says what it does, and not to come up with doctrines that will eliminate whole sections of the Constitution. So that's where I think safety lies. It's a great question. It's a really important topic. I'm glad we finally got to. As I already explained, to get on the Supreme Court, the president must nominate you, he's elected, Senate must confirm you, they're elected. And that means that ultimately the direction that the court takes is going to be influenced by politics. And so what that requires is political entrepreneurs to start making the Constitution an issue in politics, so that people that get elected to the Senate and a president that runs for president, a person that runs for president, is running in part on a plank of following the Constitution. It's got to be, the way our system is set up, for better or for worse, it's got to come through the political process before it's going to get on the court, before it's going to reach the court. That's just the only way it can be done in our system. You can't argue the justices into doing something the justices don't want to do. Believe me, I've tried it. It doesn't work. And Alan Gura tried it. It didn't work. And so that's just not the way it's going to happen. It's going to happen by this long-run political process. It's exactly what I think the Tea Party is trying to accomplish. You may like them, you may hate them, but the one word that you'll hear most often from the Tea Party is the word Constitution, or two words, the Constitution. And they've made this part of their political platform to restore the Constitution. You may think they have a misguided view of what the Constitution is, but the way you effectuate change at the highest levels is by doing it this way. It's what the progressives did very, very effectively. When they eventually, after a period of decades, got the composition of the court to reflect their views of this kind of hands-off approach towards the legislature that Teddy Roosevelt was arguing for in 1912, but it didn't really fully come to fruition until Herbert Hoover was president and he nominated some progressive justices that began the movement in the early 30s, before Franklin Roosevelt even was elected president. And so that's the way it's always been done, and it's the way it has to be done. It's not going to be done by writing clever law review articles that will persuade 5 justices to do something that they know goes against the basic narrative of what they believe to be what they think of as mainstream constitutionalism. Right, assuming that the political process is allowed to operate, and for example, the Internal Revenue Service isn't sicked on the groups that are advocating a restoration of the Constitution. I mean, the political process can be gamed. I mean, I come from Chicago. I grew up with that system. I know what that system is like. I was a Cook County State's attorney practicing law in front of the Circuit Court of Cook County. I understand what that system can be like. As long as the system is allowed to operate, that's how it's supposed to work. It's not always allowed to operate that way. It's not clear exactly, what was happening in the 2012 election with the suppression of the opposition to the current to the reigning ideology with respect to the Constitution. But look, we have to move forward. And hopefully those sorts of things won't happen again, and the political process will be allowed to work. Well, that's a difficult question. I mean, I think that the Constitution is not consistent with all political outcomes or all policies. It's inconsistent with some, inconsistent with others. But there's an awful lot in the original Constitution that progressives like and should like, and that maybe some conservatives won't like. I mean, I find that I think you may have even detected it from some of the other things I've said, that I see conservatives. I'm not talking about justices at the moment. I'm just talking about people who advocate in the realm of ideas. There are conservatives who don't like parts of the Constitution because they don't like the implications of those parts of the Constitution. And just as there are those on the left who feel that way. So I think if you stick to the Constitution, you're actually not going to get political results that completely resonate with one side or as opposed to the other. I actually think that you're going to get results that resonate with both sides, and then you're going to get results that neither side likes. But until you change the Constitution, I think that's the way that the government should be structured. In other words, I think the Constitution is the law that governs those who govern us. We need those who govern us to be subject to the law, and the only way that works is if they follow the law that they are supposed to be, that it applies to them the way we are expected to follow the law that applies to us.